Legal and Privacy Brief for August 22, 2026. Equifax agreed to a $100 settlement over 2022 credit score coding error affecting consumers nationwide. California federal court set important precedent for AI privacy litigation, ruling that allegations about what an AI tool could do are insufficient for Article Roman III standing. Congress requested a GAO investigation into CISA, the Cybersecurity and Infrastructure Security Agency's ability to protect critical infrastructure after losing nearly one-third of its workforce. CBP, Customs and Border Protection, officers and contractors systematically abused government databases to stalk ex-partners and supply intelligence to drug traffickers. Here's the full breakdown of today's top legal and privacy stories. Next section, Enforcement Actions. CBP, Customs and Border Protection. Officers and contractors abused government databases for stalking and criminal intelligence FOIA records from DHS's Office of Professional Responsibility reveal hundreds of allegations over more than a decade of CBP employees and contractors misusing law enforcement databases for personal purposes. Officers queried systems to monitor romantic interests, track family members, look up flight attendant contact information, pull data from trusted traveler applications to solicit dates, share border crossing data in divorce disputes, and provide intelligence to suspected drug trafficking organizations. One DHS employee used AdTech-derived location data to track coworkers' cell phones, the first known internal abuse case involving that data type. Compliance action. Organizations handling government database access should audit query logs, enforce purpose limitation controls, and implement anomaly detection for personal use queries. Contractors with DHS database access should review their acceptable use policies and monitoring procedures. Source: TechDirt. Next section, Litigation Updates. Equifax agrees to $100 settlement over credit score coding error. Equifax will pay $100 million to resolve a class action claiming the company inaccurately reported consumers' credit scores due to a coding error in 2022. The settlement covers consumers whose credit scores were misreported during the affected period. Compliance action. Organizations relying on Equifax credit data from the 2022 period should review whether adverse decisions were made based on potentially inaccurate scores. Affected consumers may be eligible for settlement claims. Source: Top class actions. Gemini AI tracking allegations dismissed for lack of Article Roman III standing. Thiel v. Google LLC, 2026 WL 1,970,746 ND. Cal. A California federal court dismissed privacy claims against Google's Gemini AI features, holding that plaintiffs failed to demonstrate concrete harm. Plaintiffs alleged Google switched Gemini from opt-in to default-enabled for Gmail, Chat, and Meet, allowing it to track private communications. The court ruled that alleging what an AI tool could have accessed, without identifying what data it actually accessed or used, is insufficient for Article Roman III standing. Plaintiffs also failed to show a real or immediate threat of future harm because they could disable the feature. Compliance action. This decision is significant for AI privacy litigation strategy. Organizations deploying AI features should still implement clear opt-in/opt-out mechanisms and document actual data access, but the ruling provides a defense framework when plaintiffs cannot show concrete harm from AI capabilities versus actual data use. Source: Inside Class Actions. $3.6 million Anthem denied benefits class action settlement. Anthem agreed to a $3.6 million settlement to resolve claims it denied coverage for proton beam radiation therapy for prostate cancer treatment. The settlement is currently open. Source: Top class actions. $1.5 million The Money Source Robocalls Settlement, TCPA. The Money Source will pay $1.5 million to resolve claims it violated the Telephone Consumer Protection Act with unsolicited robocalls. The settlement is open for claims. Source: Top class actions. Next section, Regulatory Guidance. FCC abandons 1 gigabits per second broadband speed goal. The FCC eliminated its long-term broadband speed goal of 1 gigabits per second downstream/500 megabits per second upstream as part of its annual Section 706 report. FCC Chairman Brendan Carr stated the goal was not technologically neutral, and that predicting long-term technological developments was impossible. The agency retained its current baseline definition of 100 megabits per second, down/20 megabits per second up. The decision benefits satellite broadband providers whose systems cannot reliably reach gigabit speeds and cable operators with limited upstream capacity. Source: TechDirt. Congress requests GAO investigation into CISA, the Cybersecurity and Infrastructure Security Agency, staffing cuts Rep. Benny Thompson, DMS, and other Democratic members of the House Committee on Homeland Security sent a letter asking the GAO to examine the impact of workforce reductions at CISA. Nearly 1,000 employees have been fired or departed since the current administration took office, representing roughly one-third of CISA's workforce. Acting Director Nick Anderson has indicated plans to hire 300 employees, but the FY 2027 budget proposes eliminating 900 additional positions and cutting over $700 million from CISA. State and local officials have reported reduced responsiveness and support from the agency. Compliance action. Organizations that rely on CISA's cybersecurity advisories, vulnerability scanning, and incident response support should evaluate alternative resources. Critical infrastructure operators should review whether their sector-specific CISA contacts remain active and identify backup coordination channels. Source: The Record. Next section, Privacy Developments. EFF Coalition calls for halt to live facial recognition in Nottinghamshire. UK EFF, Big Brother Watch, Liberty, and 5 other civil society organizations wrote to Nottinghamshire Police urging an immediate halt to live facial recognition, LFR, deployment. The coalition raised 6 concerns. LFR constitutes biometric mass surveillance treating everyone as a suspect. The nothing-to-hide argument does not hold for people seeking medical care, legal advice, or exercising union or protest rights. Planned use against children as young as 11 for antisocial behavior, Operation View, is disproportionate. LFR risks increasing adversarial police-child relationships, and polling shows 48% of people oppose facial scanning on high streets absent an imminent threat. Source: EFF. Brazil implements new intermediary liability regime after Supreme Court ruling. Brazil's Supreme Court issued a June 2026 decision clarifying its 2025 finding that the prior liability regime, Article 19 of the Marco Civil da Internet, was partially unconstitutional. 2 presidential decrees, 12/975 and 12/976, now detail implementation. Under the new rules, platforms that curate content face liability for third-party material if they fail to remove it after user notification, unless there is reasonable doubt the content is unlawful. For serious crimes, human trafficking, crimes against women, platforms have a duty of care to remove content immediately and face liability for systemic failures. The decrees require platforms to notify both the content reporter and author about removal decisions and provide appeal mechanisms. Compliance action. Companies operating platforms accessible in Brazil should review their content moderation workflows against the new notice and takedown requirements. The duty of care obligations for serious crimes require proactive content removal, not just reactive compliance with judicial orders. Source: EFF. Zero-knowledge proofs found insufficient as age verification solution analysis of zero-knowledge proof, ZKP, implementations for age verification reveals practical vulnerabilities. While ZKPs theoretically allow age attestation without revealing personal data, the token issuance model creates a single point of failure. The issuing entity can track every credential use, generating metadata trails. Authoritarian governments could pressure issuers to revoke access, effectively blocking individuals from internet services. Recent implementations of ZK snark-based systems have proven gameable and hackable. Source: TechDirt. U.S. Bank data theft claims trace to fourth-party incident. U.S. Bancorp confirmed that Lockbit ransomware gang claims of data theft are related to a breach involving a contractor for a third-party vendor, not the bank's own systems. The bank stated there is no evidence its systems, networks, or data repositories were compromised. Lockbit threatened to leak data in 2 weeks, but provided no samples. U.S. Bancorp declined to identify the third or fourth parties involved. Compliance action. This incident highlights fourth-party, subcontractor risk. Review vendor contracts for provisions requiring notification of subcontractor breaches. Ensure your vendor risk management program extends beyond direct third parties to their service providers. Source: The Record. Sick Kids Hospital suffers second cyber attack. Employee data stolen. Canada's hospital for sick children disclosed a data theft incident tied to a third-party software application. The breach exposed personal information of current and former employees, job applicants, and employees of related organizations, including the Sick Kids Foundation. Clinical systems and patient data were not affected. The hospital previously suffered a ransomware attack in 2022 that disabled pharmacy systems, diagnostic imaging, and staff timekeeping. Affected individuals have been offered 2 years of credit monitoring. Source: The Record. Next section, Policy changes. Supreme Court administrative stay in White House ballroom construction case. Chief Justice Roberts issued an administrative stay, preserving the status quo, allowing construction of a 90,000 square foot White House ballroom to continue while the justices consider the Trump administration's request to pause a lower court order that would have halted above-ground work. The D.C. Circuit affirmed District Judge Richard Leon's ruling requiring construction authorization from Congress. The National Trust for Historic Preservation argues the administration is trying to outrun judicial review by fast-tracking construction to a point of no return. The project is reportedly 65% complete. Source: Scotto S. blog. Trump administration's private sector cyber operations memo. The administration is developing plans to authorize private companies to conduct cyber operations against criminal groups. The approach would require licensed operators to coordinate with intelligence agencies to avoid conflicts with government operations. Source: Lawfare. Next section: Compliance Takeaways. Audit database access controls. The CBP database abuse revelations span over a decade and involve hundreds of incidents. Review query logging, implement anomaly detection for personal use patterns, and enforce purpose limitation policies on any system containing PII or location data. Extend vendor risk management to fourth parties. The U.S. Bancorp incident demonstrates that subcontractor breaches can generate ransomware claims against your organization. Require contractual notification obligations for subcontractor incidents and map your critical data flows beyond direct vendor relationships. Track AI privacy litigation standing requirements. The Thiel v. Google ruling N. D. Cal. establishes that alleging what an AI tool could access is insufficient for Article Roman III standing. Document actual data access patterns in your AI deployments to support both compliance and potential defense. Review Brazil platform obligations if operating internationally. The new intermediary liability regime requires notice and takedown workflows with user notification and appeal rights. Duty of care obligations for serious crimes require proactive removal. Compliance deadlines are set by the two presidential decrees, 12,975 and 12,976, assess CIS a dependency for incident response planning. With 1/3 of CISA's workforce gone and further cuts proposed, organizations relying on federal cybersecurity support should identify alternative resources and ensure sector-specific coordination contacts remain valid. That concludes today's legal and privacy brief. From Carolina, Clear Tech. For informational purposes only, not legal advice.